I will now call this meeting to order at 3:02 p.m., April 10th, 2020. Today, we have before us the case 2020-01, Fritz and Schrader versus Election Commissioner. And I believe we will first go over with, I'll just give a little brief of how this will go down, which is mostly just described in Rule 19 of the Rules of the Court, but I will go ahead and read it for you all. Here we go. The relevant information anyways. Okay. Oral arguments shall be limited to arguments presented in the brief. Arguments from the petitioner shall be heard first. After the arguments from the petitioner, arguments from the respondent shall be heard. Only one representative from each party shall be permitted to present arguments unless the court grants special permission. Each party shall be allowed 30 minutes to present before the court. The presentation time shall include all time required to answer questions from the court. The Chief Justice or the court may grant one extension of 20 minutes. This extension shall be granted to both parties and may only be granted before commencement of oral arguments. The court may ask questions to the party presenting only during the presentation of the case by that party. No witnesses shall be called during oral arguments. So, before we begin, would either party like to request the 20-minute extension?
We're fine with the 30 minutes.
30 minutes is fine by us too.
Alrighty, perfect. 30 minutes will be. And then as I assume you all got the email with the link, given that you're here, due to the limitations of Zoom, the free version, we will only be allowed to stay in this call for 40 minutes. Given that we'll probably run out of time, I will send out another link that will start a meeting shortly after this one ends, before the end of it. And with that, one last thing. After both parties give their arguments, the court will then enter a closed session, which is defined in the Iowa Open Meeting, the official meetings open to public, open meetings 21.5, and the Iowa Open Records meeting laws. That is 21.5, it's the closed session. And a governmental body may hold a closed session only by affirmative public vote of either 2/3 of the members of the body or all of the members present at the meeting. A governmental body may hold a closed session only to the extent a closed session is necessary for any of the following reasons. Then there's a bunch of reasons. We will be going with reason C, so 21.5.C, to discuss strategy with counsel and matters that are presently in litigation or where litigation is imminent, where its disclosure would be likely to prejudice or disadvantage the position of the governmental body in that litigation. That will again be repeated before we enter a closed session when we motion to do that. During that closed session, there will be minutes taken as defined in the laws of the government. And I think that's pretty much it. But after we counsel, the court will come to the decision, and then we will notify you all publicly. Before we begin, does anyone have any questions? Seeing none, then petitioner, would you like to begin with your oral arguments?
Yep, we're ready to begin. Just one more question I just thought of too. Will you be warning us as we approach time limit, or is that up for us to keep track of?
I can do that.
Okay.
Thank you for mentioning that. I didn't even
That's
know.
fine. Just didn't want to go over time, so.
Yes, I will notify you at 15 minutes, and then I'll notify you again at 25 minutes, and then I'll notify you again when you have a minute left.
Okay. Sounds good. Thank you.
Okay.
Well then, We'll go ahead and begin. So, Mr. Chief Justice, may it please the court. The petitioner holds that the Election Commission violated the Constitution of the student government by entering into a closed session, as opposed to the rules of the Iowa Open Meetings, Open Records laws, which they are required to follow under the Constitution of the government. We want to begin our oral arguments today by briefly addressing some of the arguments presented in the respondent's brief. The respondent primarily takes issue with the fact that we present Chapter 21 and Chapter 22 of Iowa Code as what the Constitution calls the Iowa Open Meetings, Open Records Act. We humbly present that Chapter 21 is entitled Official Meetings Open to the Public, Open Meetings, and Chapter 22 is entitled Examination of Public Records, also known as Open Records. These chapters are the codified language of Iowa's open meetings and open record laws. There is, in fact, no one act of the legislature which is called the Iowa Open Meetings, Open Records Act. There are a plethora of different acts that the legislature together has composed and amended over the course of 50 years to amend these two chapters of Iowa Code. None of them are actually called the Iowa Open Meetings, Open Record Acts, but all of them together have created the laws regarding open meetings and open records in the state of Iowa. Both the plain understanding and the most strict textual understanding that could be applied to this section of the Constitution and show that Article 7, Section 1 of the Constitution must be referring to these two chapters of Iowa Code. To suggest, as the respondent does, that the Constitution is not referring to these two chapters of Iowa Code raises the question that they must answer, what then is it referring to? If this is not answered by the respondent, it can only be determined by the court. It cannot have been the intent of the students who drafted and passed the Student Government Constitution to reference any other laws than these, because none exist under the title that the Constitution uses. To leave this question unanswered would effectively nullify this section of the Constitution, because it would effectively require the government to do nothing regarding open meetings and open records. Further, the respondent stipulates in their brief that the court has no authority to interpret this text so as to explain what the Constitution means by Iowa Open Meetings and Open Records Act. This suggestion is simply unfounded. Article 7 of the Constitution gives this court the power to create binding interpretations of the Constitution. If the court has no authority to interpret this section of the Constitution that has to do with Iowa open meetings laws, why did they have the authority to interpret any other section? This line of argument clearly runs afoul of the plain meaning of the Constitution's text and the obvious intent of the Constitution's writers. It is not such a radical departure from the plain meaning of the text that an amendment is necessary to explain what the Constitution means. If the respondent is correct that the court has no authority to hear this case, then they should have filed a brief in response to our petition for a writ of certiorari claiming so. In granting the writ of certiorari, the court has already acknowledged it has the power to hear this case and interpret whether or not the Election Commission violated this portion of government law, and therefore what the Constitution means under these requirements. The respondent further asserts that provisions of Chapter 21 do not apply to the Election Commission. They admit that the Election Commission is an organized body of the government, but argue that because they do not meet Iowa Code's definition of a governing body, they are exempt. First, even if they do not meet the definition of a governing body in that chapter of Iowa Code, the open meeting procedures described in the code would still apply because of the Student Government Constitution's language. This language says that all bodies of the government, even those who don't meet Iowa Code's definition of a governing body, must follow the Open Meeting Act. The student government bound itself to these rules, even if the Iowa legislature did not bind us to them. Does the respondent really seek to suggest that all organized bodies of the government shall follow the regulations and rules of the Iowa Open Meetings, Open Records Act does not apply to them? But the fact is that the student government does actually meet the definitions of an organization established by state statute. Therefore, they do actually fall under the code's definition of what a governing body is. Iowa Code Section 260C.18 refers to the student governments in the state of Iowa at Iowa colleges and universities who must determine the expenditure of all student activity fees. If a university then is to change student activity fees in Iowa, they must have a student government. This means that the university establishes student governments in order to assess fees, and that Iowa Code requires their establishment by statute at any university that assesses student fees. Iowa State does assess student fees, so the student government is a governing body required by the statute. This is the same reason why the government cannot legally discriminate in spending money on clubs because of the content they promote. Such governing bodies are bound by the First Amendment. The student government is a governing body established by the state. It therefore must be evident that the student government is bound by chapters 21 and 22 of the Iowa Code, both by the Constitution of the student government and by the laws of the state of Iowa. Finally, the respondent cites Student Government Bylaw 13.2.10.8, which states, respondent shall meet an executive session to determine if a violation of government law has occurred, and Bylaw 13.2.10.9, which states all final votes on violations shall be conducted outside of executive session and shall require a majority vote of the Election Commission. The respondent submits that these bylaws contradict our stated meaning of the Constitution's Article 7, Section 1. We agree. The Constitution states that all organized bodies of the government shall follow the regulations and rules of the Iowa Open Meeting and Open Records Act. The bylaws here contradict the Constitution by stating that the Election Commission may, and indeed should, enter an executive session without one of the exemptions that is noted within Iowa Code. When the bylaws contradict the Constitution, the higher law must prevail. We pray then that the court uses its power of judicial review to strike down these bylaws as unconstitutional. What the respondent's brief asks the court to do is to set a dangerous precedent by ignoring crucial sections of our Constitution, flaws in our bylaws, and conflicts with existing state law. The effects of such a ruling would be catastrophic for the rights of students to know what their representatives are doing. The respondent also asks the court to ignore its power to create binding interpretations of government law, which would undermine the very purpose of the court. These requests are not only unfounded, but also amount to a maiming of government law and student rights that is untenable. For the court to rule in the respondent's favor, the respondent would need to provide a clear and convincing argument that Article 7 is not referring to Iowa Code chapters 21 and 22, which are the only logical subjects of that chapter. Even if the court found the respondent's argument concerning Article 7 to be valid, the respondent would also have to prove that the student government is not a governing body, which it plainly is. Simply put, the respondent is responsible for proving that our student government has been functioning under the wrong understanding of its own constitution since the drafters wrote that constitution. Having reviewed the respondent's arguments, we now would like to reiterate our own. The Election Commission, like any other body of the government, is bound to follow Iowa Open Meetings laws by both our Constitution and existing Iowa Code. The minutes of their meetings and all evidence submitted to the court clearly show that they did not. The Election Commission violated Iowa Open Meetings Open Records law that required the commission to first publicly state during the open session the specific exemption for entering a closed session, and two, only enter closed session under specific exemption detailed within the act. The respondent does not dispute the fact that they did not follow those requirements. Due to the violation of Iowa Open Meetings law, the ruling of the Election Commission in case 20002 should be overturned, and bylaws 13.2.10.8 and 13.2.10.9 should be ruled unconstitutional. We would now like to leave our remaining time to address any questions presented by the justices.
Justices, does anyone have any questions for the petitioner?
I have a question. So, Mr. Mass, correct?
That's correct, Your Honor.
All right, Mr. Mass, in your oral arguments, you stated that regardless of whether Article 7, Section 1 of the Student Government Constitution is to exist, regardless of whether it existed or not, the Iowa State student government, all bodies of that government would be bound to follow that law because they meet the definitions in that chapter of the Iowa Code. Is that correct?
That is correct.
So you
Iowa
believe that?
Code-
Continue. So you believe that we are bound under the Iowa Code because we meet those requirements?
Yes. So the respondent's argument is that they are not a governing body under that section of Iowa Code. Iowa Code's Chapter 21 clearly states what a governing body is, and there's about 12 different requirements that if you meet any one of them, you are a governing body. One of those is that you were established by or required by a statute passed by the legislature of the state of Iowa.
Is that subsection A that you're referring to, the first one, or which one is that?
Yes, I believe it is subsection A.
All right.
So as you look over that section, it has that requirement. And as we stated in response, Section 260 of Iowa Code requires student governments to exist on campuses that assess student fees.
I believe that's my only question.
Thank you, Your Honor.
All right. With that, are there any more questions from the rest of the court? Seeing none, I believe that is all we will hear from the petitioner now.
All right.
Now,
thank you, Your
if
Honor.
the respondent would like to begin. I cannot hear you. I cannot hear anything from you. Oh,
Hello? Oh, wait,
All right.
that's the wrong.
It was working.
you may just have to make do with your
Okay. How's
laptop
that?
mic. That works.
How's that? That works? Okay. Yeah, I just had to turn it off and back on again.
Sure. Okay.
Classic power cycle. All right. Thank you, Mr. Chief Justice. Ladies and gentlemen of the court, my esteemed colleagues, for the petitioner, my name is Sandeep Stanley, Student Government Senator for the United Residents Off Campus. I represent the respondent, the Student Government Election Commission, in this action. This, ladies and gentlemen of the court, is a case of constitutional confusion. I'll recap the facts quickly for the court's benefit. On February 18th, my clients convened to discuss a campaign violation committed by the petitioner, formally filed as case 20002. During the discussion, my clients invoked bylaw 13.2.10.8 and voted to enter into a period of executive session. After this period of executive session concluded, a vote was taken on the violation in accordance with bylaw 13.2.10.9. The petitioner was found guilty of a violation and fined the fee of $100. My colleague's alleged violation of Article 7, Section 1 of the Student Government Constitution, stating that my clients follow the regulations set out in Chapter 21 of the Iowa Code. However, ladies and gentlemen of the court, we must ask ourselves, what does Article 7, Section 1 actually state? It reads as follows: all organized bodies of the government shall follow the Iowa Open Meetings, Open Records Act. You will notice, of course, that there is absolutely no mention of either Chapter 21 or Chapter 22 of the Iowa Code, regardless of what my colleagues claim in that, 50 years plus of law have been codified in Chapter 21 and 22. They do not provide any evidence of a link between the singular, very singular act cited and the laws that they callously throw at my clients. This of course, the burden of proof is on them. Regardless of how they attempt to push it on the petitioner, on my clients, the burden of proof is on my colleagues to prove as such, and they categorically fail to do so. This also far exceeds the limits of plain meaning or the spirit of the law. It just may be that this act exists. They must, again, provide proof that it does not. It just may be that this act exists and says something completely contrary to chapters 21 and 22. This substitution that my colleagues would have you make, ladies and gentlemen of the court, also exceeds your powers under Article 4 of the Student Government Constitution to create binding interpretations of said document. Enforcing the terms of Chapter 21 in this case would make an effective change to the text of the Constitution. I'll provide you a parallel example now. Article 4 further grants the court all judicial power and authority in student government. To me, those sound like very broad and far-reaching powers. It could have been interpreted to grant the court the power to create those binding interpretations of the Constitution in the context of a case, or to review legislation on a challenge to ensure compliance with external law, or to choose a Chief Justice from among your own ranks. Now, ladies and gentlemen of the court, I must ask you, what do all of those powers have in common? They were granted to the court by amendment as they changed the effective text of the Constitution. The substitution my colleagues would have you make must be held to the same standard, or it risks the integrity of the amendment process as a whole. After all, if the court can hand down an interpretation that de facto changes the Constitution, it's certainly easier to convince 5 people of the merits of the change than it is to convince 3,000. Furthermore, the terms of Chapter 21 are inapplicable to my clients. My colleague's logic has a fundamental flaw as it conflates the Student Government Constitution and the Iowa Code. In their argument, they attempt to apply an interpretation of the term governmental body based on the Student Government Constitution to the Iowa Code. This is, of course, fallacious, and especially so when Chapter 21 explicitly defines the meaning of the term within that context. Chapter 21, I believe it's section 1, or section 2, subsection C states that a governmental body is defined as a multi-membered body formally and directly created by one or more boards, councils, commissions, or other governing bodies, subject to paragraphs A and B of this subsection. In their response to our argument, I believe that my colleagues meant to cite this section as a link to why my clients are defined as a governmental body. Now, you will note, ladies and gentlemen of the court, that analyzing chapters 260 and 262 of the Iowa Code, you will note that nowhere in those chapters is student government explicitly defined or created. They are merely alluded to. To qualify as a governmental body under Section A, student governments throughout the state of Iowa must be expressly created and not merely implied. 10 classes of governmental bodies are again defined in those texts, and of course, none of them apply to my clients further than that. After all, my clients were not created by state statute, nor by an executive order of the governor, nor do they have governance over a tax-supported state district. And furthermore, I believe my colleagues have a bit of confusion with regards to our argument. We were not alleging that the bylaws supersede the Constitution in this case. No, we were merely stating that because the Constitution has been shown to be inapplicable, that we complied with all relevant bylaws and thus no violations were committed. Therefore, in view of these facts presented, ladies and gentlemen of the court, I ask you respectfully to find in favor of my clients and uphold the ruling passed in case 20002. Thank you. It will be my pleasure to answer any questions.
Do any members of the court have questions for the respondent? Okay, seeing none, then I believe that is all we will need from both parties, respectively. I will now, I suppose, as the chair, I would entertain a motion to enter a closed session of the court so that we may counsel under section 21.5.c.
Motion.
We have a motion. Is there a second?
Motion. Yep. Is there a second?
A a second from another member of the court?
I second.
Okay. With that, I would take a vote of, let's just do a raise of hands, as be easier than deciding who all said aye at the same time. So by a raise of hands, from the court, may I see who would like to enter a closed session? All right, seems that it's unanimous. So with that, we can go ahead and call this oral arguments hearing to a close. I thank you all for being here, and you will be hearing from us shortly.
Thank you.
Excellent. Thank you.